Hello, everyone, and welcome to One Civil Law, where we learn through the misfortunes of others. As always, I hope you enjoyed this legal education content, and today's the day I earned that subscription. For today's case, we're talking about be careful what you wish for because you just might get it, as we look at a Connecticut statute that helps to protect workers in their speech, but maybe helps to protect speech that Connecticut might not otherwise like. So as you are certainly aware, in most places and in most circumstances, people are free to work or not work as they like. The employer can fire them at any time. And of course, the employee can also fire the employer at any time, otherwise known as quitting. So most of the time, you can just employ or not employ as you might like. Now, of course, under federal law, you can choose to hire people or not, but you can't make that decision based on certain protected reasons. So you can't make a decision as to whether or not to hire someone because of their sex or because of their race, for example, among other protected reasons. But it's a very short list. Some states have tried to expand out this protection to include political reasons or even free speech reasons. Now, the constitutionality of these statutes is, of course, one issue, but the scope of them is an entirely different issue. And Connecticut is learning that as one person has made some speech that someone might not like, the wrong kind of speech maybe, but Connecticut passed law to protect the employer and protect the employee for their speech so they can't fire them for the speech. Let's learn a little bit more about this. On the evening of June the 9th of 2022, Miss Mumma posted a meme to her personal Facebook page. Under the banner reading, "No wonder liberals are so confused," the meme contained photos of 8 different political and cultural figures with a single word under each. For example, a picture of former NAACP Spokane chapter president Rachel Dolezal was captioned "Black." A picture of former Vice President Al Gore was captured "Scientist," and a picture of former President Bill Clinton was captured "Husband." Most relevant to the case, a photo of Senator Elizabeth Warren was accompanied by the word Indian, and a photo of Caitlyn Jenner was captured "Woman." The meme is reproduced here. Okay, so someone has some thoughts on some Democrats and how they treat certain things, and they'd like to show their contempt for how the Democrats treat certain things by showing the way that they've treated things in the past is inconsistent with perhaps basic logic. But of course, someone might have a problem with this because it's the wrong kind of speech, you see. It's the wrong kind of speech. We don't want this kind of speech. But Connecticut passed a law saying that employees should have free speech and employers can't fire them because of the free speech. Uh-oh. So now Connecticut, well, it's the wrong kind of speech, but you gave protection to it. So, all right, let's see how that pans out. Dr. Moore saw the meme on either June the 9th or June the 10th. She testified that when she first saw it, she had some concerns because she could see how people might find it offensive. Yes, free speech sometimes is offensive. That can be a thing. She was particularly concerned about Jenner and Warren because she regarded them as potentially very offensive to protected classes of people. With respect to Warren, Dr. Moore observed that the use of the term Indian in place of the term Native American can be taken offensively, but it was more the goal of this meme to question how people identify themselves. And with respect to Jenner, Dr. Moore personally found it offensive to question how a transgender person chooses to identify themselves. Well, that's kind of the point of the meme in some way. That's the problem that they're bringing attention to. It's like, yes, they choose to identify themselves in this way, but the way they've chosen to identify themselves, perhaps not in accordance with how people might understand those terms, or at least how people understood those terms 5 seconds ago, before dictionaries tried to update their definitions to be more in alignment with the woke ideology. But this person is saying, yes, this is exactly the problem. How they choose to identify themselves is inconsistent with reality. And this person says that's offensive. Reality can be offensive sometimes. Let's read more. Dr. Moore also received complaints from other employees who had seen the meme. Lee Pitts, for example, found it offensive, particularly the Jenner panel. Sarah Lissack, who was really disappointed and surprised because she wouldn't expect this from her coworker, and she regarded the meme as hateful and derogatory. Chrissy McGregor also expressed disappointment and confusion and shared that she just wouldn't have expected this harmful or hurtful post from Candace towards so many people. Oh my God. The pearl clutching is so real. The snowflakes are so real. The employees are complaining to their employer because they don't like the speech. Another employee, Kendra Williams, complained in her email that the meme was hateful, intolerant, and anti-inclusive, specifically to our transgender community. Dr. Moore groaned concern that members of the team would not be able to work closely with Ms. Mumma, trust her, have a good open working relationship with her, but at her deposition she conceded that none of these people had expressed to her directly they'd not be able to work with Candace going forward. Dr. Moore and Ms. Shields discussed the meme, and afterwards Ms. Shields convened a video conference with Ms. Mumma. Ms. Shields explained to Ms. Mumma that she is in a very visible role as a recruiter, and we need to be aware of diversity, equity, and inclusion. And her post, which is on a public Facebook page open to everyone, yes, as one does, could be seen by potential candidates, and in fact was seen by several employees who became upset by the content. For her part, Ms. Kelly Vales asked Ms. Mumma if she considered making her Facebook private, but Ms. Mumma said not. Okay. So this person doesn't really want to make their speech less private or less private. They want to make it public. They want to make everyone aware of it. They want to express some thoughts. But of course, those are the wrong thoughts. So that leads inevitably to Ms. Mumma being fired, but she sues under Connecticut Employee Free Speech Statute. Again, this is a creature of Connecticut state law because Connecticut wanted to protect speech and wanted to prevent employers from firing people for speech. Okay, so Connecticut state law says any employer who subjects any employee to discipline or discharge on account of exercise by such employee of rights guaranteed by the First Amendment to the United States Constitution or sections 3, 4, or 14 of the first article of the Constitution of this state, provided such activity does not substantially or materially interfere with the employee's bona fide job performance or working relationship between employee and employer, shall be subject to employee for damages caused by discipline or discharge and reasonable attorney's fees. So see, Connecticut wrote this law, said employees should have freedom of speech. We believe in freedom of speech. We believe that, we don't believe in these strong corporations. We don't believe in this coercive employer conduct. Okay. That raises potential problems under the First Amendment in and of itself because maybe the employer shouldn't be restricted in this way. But Connecticut thinks it should be restricted in this way. So putting aside the constitutional questions for just a second about whether the statute is itself constitutional, which, who knows. But Connecticut passed it and said, let's protect the speech. But not this kind of speech. Yeah, equal protection, baby. That's how that goes. The trial court therefore concluded that to establish a prima facie case, the plaintiff must show that they engaged in constitutionally protected speech, the employer took adverse action, and there was a causal relationship between protected activity and the adverse action. In other words, it was the speech was the reason that they fired them. In this case, the judge concluded that the prima facie case had been shown. A successful claim requires more proof of the three elements, of course, but it also requires the employee's exercise of her free speech rights not substantially or materially interfere with the bona fide performance of the working relationship. In applying the Pickering test, which, that has a whole bunch of really weird problems. So the Pickering test as a legal test, not the greatest test, but this is what we're going to try to use for all of its problems. Under Pickering, to establish this issue, we must look at workplace discipline, harmony among coworkers, working relationships, employees' job performance, responsibilities of the employee within the agency, or in this case, the private employer, because this was originally invented for the US government, because of the government trying to fire you is taking away a property interest. So this was originally written with that in mind, but we're going to apply this to private corporations now because Connecticut. Whether speech is made publicly or privately. The list of factors is not inclusive because a single mechanical test will not do for all challenges, both involving on-duty and off-duty speech, job-related and not, and spoken in protest or laughs or for just because. So the Pickering test has many sort of problems with it in terms of its application. So if you are working for the government, you are protected in your speech. But if you are acting as the employee, then they have the right to control your speech in so much as you are in an employee role, the same way a private employer would. So you can't speak for the government, for example, right? The government speaks for the government. You're their employee. You have to speak in accordance with that. But if you're speaking your own private speech on your own time, then we're on a whole nother category, right? And so then, of course, we get into the muddy middle about where exactly those boundaries are. Is this relating to your job or not relating to this job? Is this public speech or is this private speech? Is this within the scope of your employment or not? And so this Pickering test is trying to address those considerations about those issues. So if you are giving purely private speech, even if it's public facing, so if you're giving private speech, not to be distinguished from public speech for the employee, from the employer, if you're giving private speech on a private matter, then you're protected. If you're giving speech relating to your job in your contact, in the scope of your employment, then perhaps not so much. And then this Pickering is trying to deal with it, but the actual application of it can get a little bit tricky and leaves a little bit to be desired sometimes, but that's what we've got. In this case, the argument is that there's no genuine material dispute to be tried on interference prong among any of the available modes of analysis, because the court concludes that the Pickering test breaks in its favor because undisputed evidence makes clear the plaintiff publicly posted disrupted harmony among coworkers and caused concern about ongoing work relationships, as well as the ability to continue to exercise her relationship as a recruiter dealing with the public. Applying to these principles to the case, the court concluded there are genuine issues of material fact on the issue of pretext that preclude summary judgment. The proffered non-retaliatory reason for terminating Ms. Mumma is that the Facebook posts potentially violated anti-harassment law, violated company policy, and negatively impacted company operations. But when asked at her deposition to state the reason for termination, Dr. Moore didn't state this. She instead testified that Thrive terminated Ms. Mumma because she posted something to social media that was offensive and derogatory to multiple groups of people. While the doctor was concerned about the effect of the post on the workplace relationships, she did not cite potential impacts on company operations or fear of legal liability as the actual reasons for termination. While some coworkers might have complained about the Facebook meme because they're really, really soft, none of them asked the employer to take any specific action, let alone termination. Lee Pitts did not specifically ask for anything to be done. Sarah Lissick likewise did not express any specific request for action to be taken. Christine Margulis did not ask for Ms. Mumma to be disciplined, and Kendra Williams similarly did not express any action. Of course, the employer may act against harassing conduct without being asked to do so, but whereas here the employer contends to terminate an employee because of complaints of speech, it is relevant that the complaints did not request any action. Under the circumstances of this case, the jury could reasonably conclude that Ms. Mumma was not terminated because of disruption, but rather for the speech itself. Thus, that brings us to the end of the discussion of this case in Connecticut and goes to show that with the good comes the bad, with the sweet comes the bitter. And if you are a state that wants to extend protections to employees for their speech, then that may be proper. But then, of course, you have to do it for all the speech, right? You can't just be because, oh, it's a conservative employer with a liberal employee speaking. It has to go the other way around. And this person wants to post this meme and say, hey, I want to criticize people because what they're doing doesn't make any sense to me. Doesn't make much sense to me personally either. And they want to express that opinion. And Connecticut says, you can't fire them for the speech because we, as a matter of our state law, have given express protections. And the employer is like, not like this, not like this. This wasn't what we had in mind. Well, that's how it goes. So an interesting case in Connecticut showing some special protections under Connecticut law for speech from an employee that wouldn't normally be protected, but Connecticut said, how about the protection? And this meme might also be protected as a result. So go forth in your lawsuit, go get yours. At least for the moment, that brings us to the end of discussion of this case.